Welcome to a new panel of the Society of International Economic Law for everyone in the south part of the globe, and good evening or good afternoon for those who are in the north part of our globe. We have a very, very interesting panel to propose to you. We are going to speak today about the new generations of free trade agreements and normative values. The main question will be is it all about the money? And we have such a distinguished colleague to share and to discuss that question. We will have today Professor Pasha, Hsieh, from Singapore Management University. He's an associate professor and associate dean also, and faculty matters and research at the Singapore Management University at the School of Law, actually. And he's also member of SIEL, of the Society of International Economic Law. We have here today also Professor David Gantz. David is the Will Clayton Fellow for Trade and International Economics at the Baker Institute for Public Policy, at the Center for the United States and Mexico at Rice University. And he's also Professor of Law Emeritus at the University of Arizona, Rogers College of Law. We have also here Professor Jessica Lawrence. Professor Jessica is a senior lecturer in law at the University of Essex at the UK. And finally, a special thanks to Professor Csongor, who actually organized this panel. Professor Csongor is Professor of Law at the University of Szeged and a research chair at the Center for Social Science at the EDVOS Laurent Research Network. He's a visiting professor at the Central University, European University. I think this is in Vienna located, and Sapienza University of Transylvania, that's in Romania. So we have very different perspectives, and I think that we will have a great, great discussion. So welcome all of you, and thank you very much for sharing with us this session. We will start with Professor Pasha Hsieh. Professor Pasha, if you are ready to start.
Well, thank you very much, Valentina, for your kind introduction. So I'm very glad and privileged to join this panel. And today, I will focus on the EU-Singapore FTA. And this FTA formed the basis for the future EU-ASEAN FTA. So it's critical to the concept of interregionalism. And today, I will talk about non-traditional trade issue. So let me provide the historical background of the three waves of interregionalism as well as EU-ASEAN legal framework. The first interregionalism took place in the 1970s. The EEC Economic Community, European Economic Community was formed in 1957. ASEAN was formed in 1967, and EEC became ASEAN's dialogue partner in 1977. And the second interregionalism started with the 1980 ASEAN-EEC Cooperation Agreement, but at the time, ASEAN complained about the EEC's protectionist policies on ASEAN's agricultural products, and ASEAN was also unhappy about EEC's GSP because they feel that the ACP countries got much better deals under the Lomé Convention. And in 1994, it is for the first time the EU issued the New Asia Strategy, and a very important interregional dialogue forum was formed. This forum is known as ASEM. This was based on Singapore Prime Minister Goh Chok Tong's initiative with the support of French President Chirac. And in the third regionalism, which started in the 2000s, very recently, the EU elevated the dialogue partnership to a strategic partnership. And in 2021, last year, EU also issued the very first Indo-Pacific strategy. So there are fundamental geopolitical issues in the third interregionalism, including the following. The CPTPP and the RCEP was concluded. The RCEP was based on the notion of ASEAN centrality and include all ASEAN countries. And now the EU also see China as so-called systemic rival. So the EU also seek to increase and enhance ties with other Asian partners, including particularly ASEAN. And also, we're now suffering from the COVID-19, which has led to a 32% plunge in global trade, so that the prospective EU-ASEAN FTA will help us revitalize the economy. Okay, so in 2015, the EU articulated the Trade for All policy. So the European Commission came out with the building block approach for realizing the EU-Singapore FTA based on bilateral so-called Pathfinder agreements. So Singapore and Vietnam were identified as the primary targets. The original EU-Singapore FTA was they launched negotiations in 2009, and they were the FTA was finalized in 2014. At the same time, the EU-Vietnam FTA was also signed in 2017. This also relates to EU-ASEAN FTA negotiations. So in 2007, from 2007, both blocs negotiated a region-to-region FTA, but the negotiation failed in 2009. But in 2017, both sides decided to talk about the resumption of the EU-ASEAN FTA. In 2017, the CJEU issued a landmark opinion called the Opinion 215. And this opinion relates arose from the EU-Singapore FTA and also relates to the EU's exclusive competency. So in this case, the court found that the provisions on non-foreign direct investment and ISDS fall outside the common commercial policy. So because of this decision, Singapore and EU decided to split the original FTA, which was finalized, into a new FTA and a new IPA, Investment Protection Agreement. And the European Parliament ratified both FTA and IPA. FTA is considered as an EU-only FTA, so they became effective. And IPA is considered as mixed agreement, so it will only become effective after 27 member states ratify it. And Vietnam followed the same approach, and the EU-Vietnam FTA also became effective in 2020. So in order to understand the bilateral agreements between the EU and Singapore, we need to understand that the FTA and the IPA and the PCA, Partnership and the Cooperation Agreement, are actually intertwined. And Singapore is EU's third FTA partner in Asia after Japan and Korea. And Singapore is also the very first FTA partner in ASEAN. And EU-Vietnam FTA is considered as the most comprehensive trade agreement that the EU has concluded with a developing country. And IPA, a lot of discussion relate to IPA are about the ICS, the two-tier investment core system. And PCA primarily addresses cooperations of human rights and sustainable development. The EU-Singapore FTA is also very important to the Brexit, because the UK withdrawal agreement say that the agreement will cease to apply to the UK at the end of 2020. However, the UK and Singapore negotiated a new FTA, which became effective in 2021. And this FTA is very easy. And this FTA only got 36 articles, because Article 1 of the FTA says that the UK-Singapore FTA will largely incorporate the original EU-Singapore FTA. So now I provide a comparison between EU-Singapore FTA and EU-Vietnam FTA and other agreements. So the two FTA are very similar. And of course, in terms of tariff concessions, in terms of copyrights, and the EU has considered the different development stage of Vietnam. But in terms of SOE, state-owned enterprises, there's no specific chapter on SOE, whereas there is a specific chapter on SOE in the EU-Vietnam FTA. And the ICS investment core system are roughly the same, although they have different numbers of judges for the tribunal of first instance. In terms of rules of region, and that relate to non-traditional trade issue that I want to mention, we know that rules of region largely based on CDC or RBC. And the EU-Singapore FTA adopted co-equal rules, so you can use either CDC or RBC. And a very important concept is the ASEAN accumulation. So basically, the EU-Singapore FTA adopted 40% as the RBC benchmark, so that goods that incorporate materials produced in other ASEAN countries can also benefit from EU-Singapore FTA. So this is actually very good for regional development. And also, the rules of region also have a very unique rules concerning Asian food products. I think we all agree that food represents values, and particularly Asian food. So this is the very first EU FTA that allow Asian food product to be exported to the EU duty-free. Okay. So it has more very liberal rules, and also very interesting that the Annex B to Protocol 1 also identify many Asian foods such as rice noodles, wrappers for baking dough, even include Chinese translations. And non-tariff barriers are important, as the EU-Singapore FTA has a specific chapter on NTB that apply to renewable energy generation. The chapter also identifies renewable and sustainable non-fossil sources, and also oblige parties not to adopt local content requirement, partnership with local companies, or discriminatory licensing or authorization procedures. So it's very important to the green industry. The chapter also includes several rules that will be very useful for us to fight against the COVID-19 pandemic, because this provision help reduce technical barriers to pharmaceutical and medical devices. We also agree that sustainable development and human rights represent so-called European values, and they are also considered as new generation FTA components. So EU-Singapore FTA has a specific chapter on trade and sustainable development. However, it also reflects a compromise, because the FTA excludes this chapter from the general DSM. Instead, the EU-Singapore FTA has chapter-specific DSM that include government consultations and panel of experts that would issue reports that are monitored by a jointly established board. And in 2018, the EU issued a 15-point plan that calls for implementation of DSD chapters. And this is also a concern for many ASEAN countries, because when they sign FTA with the EU, they think that they will never get sued. But now we have a case arising from EU-Korea FTA. In 2021, the panel held that Korea breached labor law commitment, particularly with respect to the freedom of association. In terms of human rights, and it's very important to understand the nexus between a PCA, Partnership and Cooperation Agreement, and FTA, because the European Parliament required a PCA to be a prerequisite to an EU FTA. And PCA and FTA actually form a common institutional framework. The EU has criticized Singapore's human rights since the 1980s, particularly Singapore's ISA Internal Security Act and mandatory death sentence. And it's very interesting because I did some research and I realized that the number of detainees under ISA or death penalty cases have not changed significantly. However, a lot of commentators argue that European constitutions, including European parliaments, actually show little interest in promoting human rights conditionality in negotiating with Singapore. And in contrast, the EU adopted very hard stance on Vietnam. And the PCA also includes a side letter saying that none of Singapore's current law lead to the invocation of non-execution mechanism. In other words, current law will not be challenged. This is also very different from the Canada-EU Strategic Partnership Agreement, which says that a particular serious violation of human rights could serve as grounds for the termination of the CETA. So there's no such provision in the EU-Singapore FTA or PCA. So I've talked about the third interregionalism and the EU-Singapore FTA as pathfinder agreement for the EU-ASEAN FTA, as well as non-traditional trade issues. And I have more details in my new book, New Asian Regionalism in International Economic Law, which will be published next year. And and I have included more detailed information in the book. Thank you very much.
Thank you very much, Professor Pasha, Hsieh, for your excellent presentation, very clear and on time. Thank you very much for respecting the 15 minutes we were given to expose our ideas. While you were talking, I was contrasting your experience with the EU agreement with Mercosur, EU agreement
Yes.
that we negotiated in 2019. And many things that you told us relates directly to our experience in that negotiations.
Yes.
But leave that for the dialogue better. And please welcome Professor David Gantz. Professor David, the floor is yours.
Thanks very much, and glad to have the opportunity to learn more about EU, Singapore, EU-Vietnam relations. I am going to make an effort to post the PowerPoint, and we'll see how that goes. Okay, I guess it worked. I'm trying to stick to the topic that was given us, but realistically, I'm focusing mostly on the United States-Mexico agreement, NAFTA 2.0, the replacement for Mexico that went into force just slightly over 1 year ago. A few comments focusing on these issues that are raised, norms and money, but mostly what I want to do is to talk about a very far-reaching agreement. The goals are not that different, I don't think, from the EU or other FTA goals. You're trying to encourage trade, investment, and job creation. In North America, we're trying to become or maintain our competitiveness with Europe and Asia. There's a broad body of thought that thinks national security is greatly related to better economic security. Clearly, there is an effort to establish new and modern standards for trade agreements. Perhaps the outstanding feature of USMCA, though, is a mechanism for protecting worker rights, which to me at least seems for the first time in any FTA actually has a chance of working. There is much interest in, obviously, in trade in environmental policies, but one must keep in mind the context of this negotiation, where it was managed by a group that refuses even to mention the words climate change in an international agreement, which makes it a little bit more difficult. There is reference to sustainable development in a number of places. How effective and important that is, I think, remains to be seen. Probably the most important aspect of USMCA, if you think about it, NAFTA was negotiated in 1991 and 1992. It's almost 30 years old. Wasn't much coverage of e-trade or internet issues or digital trade because there wasn't much of that. So obviously there was a serious need for modernization, and a lot of this, to be perfectly honest, was taken from the Trans-Pacific Partnership, which U.S. withdrew from in early 2017, but the Obama administration was one of the main negotiating parties. So I'm going to talk a little bit about NAFTA's legacy, then an overview of the agreement, some of the challenges, and then a few other factors. It's worth keeping in mind for those who are not North American academics or lawyers that we're talking about a huge amount of trade, about $1.2 or $1.3 trillion among the three countries in a good year, which I assume we will have again certainly by 2022. The U.S. For the U.S., the trade volume with North America is much greater than it is with either China or the EU. And for Canada and Mexico on the other side, which of course are much smaller economies, for each one of those, about 75% or more of their exports go to the U.S. Mexico and Canada both have agreements with the EU. They both have many agreements with other countries, but their trade with the U.S. still dominates. So you have a lot of trade. You had probably more important, a very deep integration of the North American auto market, particularly in autos and other manufacturing, competitiveness issues, much job creation, although obviously some job loss in the U.S., probably not significant overall, but still significant to the people who were affected. There were loss of some jobs to Mexico. But for example, in the auto industry, the U.S. industry produces the same number of cars it did 30 years ago with 20% of the workers. So that's the biggest problem. The major dislocations of small farmers in Mexico, weak enforcement of labor standards, and very little interest in environmental standards or sustainable developments. It basically was a trade agreement that eliminated tariff and non-tariff barriers, mostly very quickly, but a few longer than that. Very complex rules of origin, even more so than the ones our previous speaker was talking about with Singapore and the EU. Labor and environmental provisions were in there as add-ons, side agreements, but basically they were useless or very close to useless. And for a trade agreement that went into effect in 1994, its coverage of services, intellectual property, some of these other aspects were quite extensive, and it did apply to temporary entry for business, but it needless to say, it sidestepped general immigration provisions. ISDS was the standard third-party arbitration focused on ICSID. Binational review of national dumping and countervailing duty determinations was unique to NAFTA and unique to USMCA. It's never been replicated elsewhere. If people are interested, I could talk about that in the question period. And it's worth keeping in mind, although we don't pay much attention to the US-Canada FTA that preceded NAFTA by about 5 years, a great deal of NAFTA comes from that earlier agreement. USMCA has been enforced just over a year. July 1 was the anniversary. Unlike many trade agreements, there was huge bipartisan support, including from liberal Democrats and labor unions. It's really too early to tell much about the impact. First of all, most of it's phased in over 3 to 7 years, so you don't see the full changes for quite some time. I think in the short term, probably the most important change was that the risk that NAFTA would disappear, which went on for 3 years or so, has gone away. So businesses are not afraid to invest in that sense. But of course, the pandemic has overshadowed NAFTA for pretty much its entire, not NAFTA, USMCA, for it's pretty much its entire lifetime. So until the U.S. is recovering in most parts of the country fairly rapidly from COVID-19. Mexico, it's much slower, but the manufacturing sector there seems to be getting very quickly back to normal. Again, 70% or so of the agreement is very much like NAFTA, so if you know NAFTA at all, you won't be surprised by what's in here. And a good part of the rest has been borrowed from the TPP with some modifications, but not always very many modifications. It's a mix, because I think certainly the modernization has been very positive for most stakeholders. Automotive rules of origin and limits on future agreements with China, I think, are unduly protectionist. It's a wide and deep agreement like the TPP, CPTPP, and with many of the EU's agreements in Asia and elsewhere. It's a mix, though. Positive changes, intellectual property, SMEs, SOEs, e-commerce, digital trade, the whole litany. Environmental protection is much better. Labor standards, though, is the area where you really have an enforceable mechanism, and New Mexican legislation, a rapid response dispute settlement mechanism, which has already been invoked a couple of times in the last few months. We'll have to wait and see how it works. The idea is to make it possible for Mexican workers to form independent unions, ones that are not connected to a major political party, and engage in open, meaningful collective bargaining. This sounds great, common if you're from the EU, but it's very, very rare. It has been very, very rare in Mexico. So there's some other aspects as well that I could talk about if we had time. Currency manipulation is addressed. Mostly just, I think, to set a precedent. It's not a problem in North America unless you believe what the Fed does from time to time is currency manipulation, which some of us wonder about. Dairy market in Canada is very closed. We get more access a little bit. Most agricultural trade between the US and Mexico and the US Canada won't be changed, and those are two of our three biggest export markets for agriculture. There's a much better state-to-state dispute settlement mechanism. It's now virtually impossible for one member, the US of course, to block the mechanism simply by refusing to appoint panelists. And the provision in the TPP protecting biologic drugs and some other drug issues went away when the Democrats insisted on it. Automotive issues, it's just more protectionist. You need a higher percentage of local content. You have to produce 40% of cars and 45% of trucks, including parts, of course, in facilities that pay $16 an hour, which is intended by the previous administration to cut out Mexico, and will probably have some impact there. But there is a phase-in provision, and at some point after 7 years, the steel has to be melted and poured in North America, and the administrative record-keeping costs, particularly for tracing the $16 an hour, are going to be an added expense for production. Investor protection, now, obviously there are some who think it's wonderful that investor protection is going away. Basically, Canada and the US, there is no ISDS after a 3-year phase-in period. With Mexico, you have what used to be considered normal ISDS, third-party arbitration, for oil and gas, electric power, transportation, and a few other things. But everything else, you have an exhaustion requirement, a fairly limited mechanism which says no fair and equitable treatment claims and no indirect expropriation claims. Doesn't apply to Mexico and Canada. They're both TPP parties, so those mechanisms, which are more traditional, apply. It's interesting, I think I will note that there are legacy investments. There's a 3-year period from July 1, 2020, where you can still bring cases under NAFTA for investments made before 2020. And this is important because there are going to be, I think, quite a few investment claims against Mexico over the next year or two. You have a sunset clause, which is better than it was before. The original Trump proposal was 5 years. There's this strange provision saying Canada and Mexico can't conclude trade agreements with China. In legal terms, the last administration's Mexico opening up the hydrocarbons market and the electricity market are preserved, but it's rather strangely put together. So the fact that the U.S. has to be treated the same way as the TPP partners is not as clear as it might be. You have no treatment of our famous bogus national security tariffs on steel and aluminum, although they don't apply to Canada. Government procurement disappears between the US and Canada. And needless to say, there's no mention of climate change. And there's nothing in there that can really force parties such as Mexico who have really little interest in reducing greenhouse gases to do so. The Democrats, basically the agreement was signed in November of 2018, but it took a year before the Democrats and the Trump administration could work out some details, mostly labor enforcement, environmental, the biologic drugs issue, and state-to-state disputes settlement. But most of NAFTA is still preserved for the stakeholder. Almost everything is duty-free, quota-free in trade among the three countries. You have that strange mechanism for anti-dumping and countervailing duty case reviews. Canada, cultural industries are protected, and it's extended to Mexico. There are a lot of challenges and opportunities. I think Mexico could attract a lot more foreign investment in clean energy, as well as autos and auto parts and steel, if the investment climate improves, but I think that's very unlikely. The new labor provisions could raise wages a little bit in Mexico, but I don't think it would get rid of the 5 or 6 or 7 to 1 ratio with the US. I think US contents of autos and small trucks probably will increase, and that was certainly the previous administration's intent, but it's going to increase the cost of the products. And how do you know how competitive the products will be with those that are imported. And it's worth keeping in mind that while the U.S. Small truck industry is very well protected, a 25% duty, automobiles come into the U.S. at 2.5%, which probably is less than the administrative costs of meeting the USMCA requirements. Again, there's a lot of talk about environmental protection and trade in the environment relationship, and there are mechanisms which could be used if the parties wish to further these goals, but it's really a very open question as to whether they ever will be, more likely under this administration than some others. So what about this, just the money? Well, first of all, I would say, what's wrong with money and profits as long as everyone is subject to reasonable regulation, which of course is easier said than done. Successful regional trade agreements, which are necessary since the WTO is paralyzed in terms of negotiation, I think have a pretty good record, at least with USMCA and certainly with the EU, maybe less so with Mercosur, stimulating trade, investment, and job creation. I think they help to provide consumers with goods and services, and they do help to set the rules of the game, which isn't happening in Geneva. And I think these are the objectives of trade agreements, whether you're talking about the US or Canada, democratic socialism in the EU, or centrally planned economies like China and Vietnam. They're pretty much the same. I think we all have recognized that trade agreements are necessary adjuncts to economic development, but they're not sufficient. Domestic policies, taxation, economic and political stability are important. If you don't want trade and profits in the system, as I have told my trade law students for many years, study the Soviet Russia, North Korea, Cuba, or Mexico before 1985 for the alternatives, which are pretty grim. Thank you. I will stop with that.
Thank you so much, Professor Gantz. It was, of course, a clear, to the point, and provocative exposition. Very, very well done, Professor.
Thank you.
I took note many aspects that you emphasized that I think we have to bring into the table again in the dialogue. You stress the trade dimension in the first phase of the NAFTA agreement, where labor was on paper but not enforced. And I think that you in a very detailed way, you point out the new dimensions, aspects that are in motion in this new trade agreement. And I think that we should discuss further about the implication of the new generations of agreements in terms of multilateralism, on terms of COVID, on terms of value chains. And one thing that you said, just passing on, was that neither Canada nor Mexico can do agreements with China without US approval. And I was thinking, how you do that if you don't have a common commercial policy? I was thinking myself, you don't have a external common tariff, and how you do that. But keep it for the dialects. Really nice presentation. So let me welcome Professor Jessica Lawrence now. Jessica, please, the floor is yours.
Okay, let me just share my screen. First of all, thank you. I'm very happy to be here. Thank you to Csongor for putting together the panel and inviting me. And thank you to Valentina for chairing. And of course to Pasha and David for some really great presentations so far. I'm learning a lot myself. So I'm going to be sort of just throwing out today some initial kind of thoughts that I've been having about a couple of big agreements that were sort of brought before us in 2020 in the EU. And I'm talking here about the EU-UK agreement and the EU-China investment deal, which we now have a draft of sitting on the table. And excuse the flowery title as well. I am living in the UK now, and I am required to make a certain number of allusions to Dickens and Shakespeare as a condition of my visa. So this is getting it out of the way early this year. All right. So just a tiny bit of background. I think, Pasha has already gone through a little bit of this, so I'll go a bit quickly. The EU basically has this approach to trade and investment policy that is meant to incorporate sort of social norms, right? Environmental norms, labor norms, nowadays, SR stuff and things like that. This is partially because it's required to mainstream environmental protection into all EU policy areas. It's partially a kind of values-based preference. The EU has long been trying to, wiggle labor requirements into multilateral agreements, at least it was back in the day, and through GSP and all this kind of thing. But since 2008, labor and environmental standards have really become a kind of core part of what the EU does in terms of negotiating trade and investment deals. And since the Korea FTA, which was negotiated, I think signed in 2009, came into force in 2011, was applied provisionally in 2011 and then actually entered into force in 2015. These have come in the form of chapters, Trade and Sustainable Development chapters, TSD chapters. Okay, so what exactly do these TSD chapters do? Specifically, first, they incorporate a series of commitments on labor and the environment. These include sort of, your traditional preambular aspirational type of things, as you'll find in lots of different types of economic integration agreements, affirming your commitment to sustainable development and so on in a general way. And they also include a bunch of sort of cooperation, general cooperation, transparency commitments, and that type of thing. The two most significant parts of these chapters are the sets of commitments to respect and effectively implement and work toward the ratification of international agreements, multilateral environmental agreements, and labor agreements, and then commitments to effectively enforce domestic environmental and labor laws. Now, on the international agreements, those usually contain sort of two categories of things. One is on the environment side. The agreements normally don't require ratification of further agreements. They just require the effective enforcement of any multilateral environmental agreements that the parties currently subscribe to. And then on the labor side, it's about that same effective enforcement of treaties that they've ratified, but also about respecting, promoting, and realizing the principles that are the subject of the ILO fundamental conventions. That's what South Korea got tapped for by the panel that was set up to arbitrate between South Korea and the EU on issues of collective bargaining and so on. And they have a further provision on labor generally, which is that the parties agree to make sustained efforts to ratify and implement whichever fundamental ILO conventions they haven't become a party to yet, as well as some other up to. And those will often specifically name a couple of ILO conventions. That was the case in the South Korea arbitration as well. That part of the EU's arguments failed on the grounds that making sustained efforts isn't actually the same as promising to do it by a certain date. And so, okay, well, South Korea hadn't violated that part of the agreement. All right, so that's on the international instruments part. On the domestic rules part, what these EU agreements typically contain is first a non-regression clause, essentially committing the parties not to weaken their current levels of environmental and labor standards for the purpose of attracting trade and investment. And second, a kind of non-enforcement clause, which is about the parties agreeing to enforce or not to you have to say it backwards, the parties agreeing not to fail to enforce their current environmental and labor laws in a way that affects trade and investment. So you've got this non-aggression clause and then this non-enforcement clause. These are basically anti-race to the bottom type provisions that look to prevent unfair competition, let's say, when it comes to on the basis of poor environmental or labor conditions. Okay, and in addition to these substantive provisions, they set up a series of governance and enforcement mechanisms. So primary among these, and Pasha already referred to the government consultations, which are permissible under these chapters, as well as the use of expert panels in the more modern agreements to hear disputes about violations of the chapters. These are chapter-specific dispute settlement provisions. The normal dispute settlement in these agreements is not generally available for these type of violations of the TSD chapters. And there's another mechanism which has developed, which is the use of so-called domestic advisory groups and civil society forums as a kind of watchdog, theoretically, for making sure that these chapters are applied and enforced. What those are is basically meeting where sort of representatives of business and civil society, NGOs, labor unions, so on, will get together and talk about how the agreement has been affecting them. Each one of the parties has its own DAG, and then the DAGs once a year or so will meet together in the civil society forum along with representatives of the government to sort of talk through what problems have happened. Okay, so this is how the enforcement of these chapters has worked so far. Of course, the Civil Society Forum and the DAGs might be called slightly different things in different treaties, or might meet on a slightly different basis or schedule and this kind of thing, but this is the overall structure. Okay, now there's a lot of criticisms of all of what's been going on here. You know, the effective enforcement provisions are weak, the international standards provisions are weak, the domestic advisory groups can't really make the commission do anything. So, you know, that's all kind of has to be sort of peer pressure rather than a legal mechanism and so on. But still, this is sort of been, generally speaking, on a track within the EU toward kind of a more enforceable, more judicialized mechanism. So over time, we've gotten more binding language in these agreements. We've gotten them to cover a greater scope of issues, including things like climate change. In the new agreements, the EU has been including under those commitments to enforce one's own multilateral environmental standards, the commitment to uphold all of those nationally determined contributions that countries have made under the Paris Agreement and so on. So this is all kind of growing and growing. We've moved toward sort of more kind of oversight away from just the pure sort of cooperative mechanisms and consultation mechanisms of the past. We've got these kind of proto-oversight mechanisms in the DAG and with the expert panels, which can issue public reports and so on. Okay, so this was a sort of trajectory over time that was kind of slowly building up toward more enforceable mechanisms until this year. This past year, 2020, when everything went haywire. So we had, on the one hand, the EU-UK agreement in January, which through the whole sort of history of the EU being committed to sort of cooperative work on trade and labor and trade and environment out the window, and put in place a whole bunch of sort of enforcement mechanisms attached to the TSD provisions that are inside the EU-UK agreement. I'll sort of set out the most important ones in just a second. And on the other hand, you had the EU-China agreement in December, which also includes a sustainable development chapter, That's an investment-only agreement, so it's a little bit different, but it's sort of borrowed from the whole sort of sustainable development practice from the comprehensive trade and investment type agreements that the EU had been concluding recently. And in that one, the provisions that have been being built up in agreements like Singapore and Vietnam and Korea and so on have been watered down. So there's more sort of conditional phrasing, the DAGs are eliminated and so on. So we've got opposite pathways opening up in 2020 that really call into question this trajectory of a steady build toward increasing judicialization. Okay, so briefly, obviously this is a massive agreement and there's tons of stuff in it, but just to give a few examples of how the EU-UK agreement went way farther than any of the EU's previous agreements in terms of requiring commitments on labor and environmental stuff. The EU-UK agreement has a whole level playing field section, which includes new requirements on tons of things, including a requirement that the parties shall put in place carbon pricing systems, and that the UK and the EU both agree to put in place supply chain management rules and all sorts of things that go much farther than previous agreements on the substantive side. Also on the enforcement side, and this is where it went completely sort of off the charts, suddenly we have things like those expert panel reports. Same thing, you have an expert panel, they can issue a public report, but now they're going to be monitored for compliance by a committee, and the DAGs can talk to the committee and tell them if there's no compliance. And if a party doesn't comply, then you can suspend obligations, equivalent to the nullification or impairment of benefits. This is a kind of modeled on a sort of countervailing duties for subsidies kind of thing. You also can take rebalancing measures if you determine that the other party has significantly diverged from you in terms of your labor, social, environmental, or climate protection rules. And this basically means, border tax adjustments, and it means, tariffs that can be put in place for these various things. So suddenly there are real teeth in the TSD chapter in a way that there never have been before. Versus the EU-China agreement, where, okay, it's good that there's an SD chapter, for those of us who care about such things, in an investment-only agreement. We didn't necessarily know what that would look like, because most of the time we come with this package of trade and investment agreements and so on. But the provisions in there are all watered down. So on the effective enforcement side, that non-enforcement of domestic law is not appropriate, an appropriate basis for competition. There's a resource allocation flexibility provision that says that, essentially the parties can make their own determinations about where to allocate their money in terms of trying to enforce the labor and environmental, their own labor and environmental laws. And this is not entirely new. There's one of these in the EU-UK agreement. There's one of these in EU-Colombia-Peru. But in all the other places where such a resource allocation provision appears, it's qualified that it has to be exercised in a manner not impacting the other obligations in the chapter. This is now missing from the draft of the China agreement. Okay, so we've taken out this little provision, this little extra language. Similarly, on the ratification commitments, those continuing and sustained efforts to ratify ILO core conventions, well, China, it turns out, has not ratified several of the ILO core conventions. But here, it adds an additional qualification that those efforts have to be made by each party on its own initiative. Okay, so this would seem to, further a provision that already by the EU South Korea panel had been sort of weakened through their interpretation but the lack of a definitive kind of deadline for ratification meant it wasn't violated by Korea in that case. Okay, so we've got a watering down there, and also weaker enforcement provisions. So the whole DAG system is gone, essentially, because by all accounts, China was not very excited to have civil society input into the policymaking process outside of the places where it already chooses to allow such things. And so this appears nowhere in the agreement. Okay, so we have Agreement A going way farther than anything has before in terms of substantive commitments, in terms of enforceability, putting the EU's previous insistence that it could not do coercive trade policy, and it was all going to be about, cooperation and persuasion, into some major question. And a second agreement in which, we had a weakening of all of the standards that have been building up. This building block approach, this whole thing, like it's all gone haywire with the EU-China investment agreement. And so the question we're kind of left with is, what's going on here? Now, I think the easy answer is, well, it's the geopolitics, stupid, right? I mean, it's all about sort of, well, China's China and the UK is the UK, and the EU has very different priorities when it comes to each one, and very different sort of power balance in terms of what the negotiations are in each of these cases. But I think also, it raises interesting questions for us as lawyers about what the field of possibilities actually is for, the EU's sort of trade and investment policy. Clearly, it can include enforceable provisions and actual consequences and teeth in the TSD chapters if it wants to. I mean, of course, we already knew this to a degree. The US was already doing it, before the EU, weak as they also might have been, as David pointed out before. It went farther than what the EU had. But now we see that the EU can put them in when it feels that it's in its interest to do so. And we also have learned a nastier lesson, which is that if another country is sufficiently opposed to these things and the EU wants to trade or invest or investment protections badly enough, or market access or what have you, then it's willing to set aside its values in order to sort of get that job done. So much for normative power Europe. All right, that's all I have. I really would love to hear some thoughts from everybody else on what happened in 2020 and whether EU trade policy.
Thank you so much, Jessica, for such an excellent that puts on the table the oldest discussion in international relations about legalization, judicialization, if you need power to make the rules work or not. I was thinking when you were doing your presentation about the trajectory on the discussions at the academic level we had on the legalizations of international relations and the limits of legalization when one big power retires itself from the system. And we have and it has been very difficult to sustain institutional and legal systems without the support of stakeholders or biggest stakeholders. So very to the point, your presentation, to the heart of the problem when trying to set up institutional and legal commitments. I was thinking also when you were revising legal language that one strategy that arose at the Mercosur-EU negotiations, instead of asking to adopt an international agreement that was politically or problematic for some governments, we decided to phrase it in another legal way, so you don't have to adopt the instrument, but to comply with the commitment of the agreements, which has the same effect, but you are not committed to sign the agreements. Let's say, whatever, one in copyright that comes to my mind. comply with the commitments that arise from that international agreement. So that sometimes works as a little, to get to the same result with another legal. Very, very good presentation. And finally, we have here our Professor Csongor Nagy, who is the organizer of this panel. So we were waiting. We are glad that you are here. And so the floor is yours, Csongor.
Thank you very much. And thanks for giving me the floor. It's a real pleasure to be in this panel. And actually, I've already learned quite a lot concerning my own topic, because I chose a rather philosophical perspective for the subject of today. So I tried to be as academic as possible, meaning that my paper will deliver very probably the least practical use to the audience. But I will try to do my best. I'm sharing my slides. I have a rather complicated title, I guess. Please give me a second. I don't see.
Minutes to tell the people in the audience. We have many people following this this panel, that if they want to do questions, please to post it in the public chat. We will be alert to that, to include your questions and comments in this panel.
Yeah, thank you very much. Let me just double check if you can see my slides, because they should work now.
Oh, yes, we are seeing it.
Okay, perfect. So actually, my title is Trade Interests and Extraterritorial Value Considerations in New Generation Free Trade Agreements. But actually, I'm looking for the motivation behind these provisions. So that's maybe the most important purpose of my inquiry. I'm referring to these value standards, labor standards, environmental standards, as extraterritorial requirements, because in these cases, one state expects the other state to do something on its own territory. So this is why these are extraterritorial value standards. And of course, it's very easy to be cynical about these value standards. I'm just referring back to the presentation of Jessica, where we could see how different approaches may prevail regarding different countries. Quite a few cases, the observer may have the impression that in these treaties, especially the EU, is actually not creating standards. The parties are just recognizing the standards they already have, and they are putting them into the treaty. But when there is a hard resistance, then these provisions or these chapters tend to get watered down, softened. I have two references actually at the beginning of which I need to mention at the beginning of the presentation. My speech is based on a paper I published in the Journal of International Business and Law, and there's a edited volume which is coming up, and it's dealing with the very same issue. We have value standards in international treaties, and of course we have selfish economic interests. Now, what is the dominant motivation behind having extraterritorial value considerations? Is it money, or do we really have real value considerations? So it's more like a chicken or egg issue here, but very probably the answer will be both. If that's a conceivable answer at all. Probably my favorite metaphor when dealing with policy decisions and trade policy decisions specifically. So my most favorite metaphor is the Baptist bootlegger coalition, which I took from economics literature. It's not my invention, obviously. When the state makes decisions, and that applies not only to international trade, there are quite often two sorts of interest groups behind that: Baptists and bootleggers. The metaphor refers to the prohibition of alcohol, and the story is the following: the prohibition of alcohol is supported by two stakeholders, two interest groups: the Baptists, who support this prohibition for moral reasons or because of moral reasons, and the bootleggers, who are actually making money off the prohibition of the black market, and they also support the prohibition. The economic reason behind that is very simple. If there's no black market, then the bootlegger would lose his job and his living. So the prohibition of alcohol, which appears to be a provision, a law, a rule justified by moral considerations, it may be actually supported by bootleggers, by criminals themselves. And this shows us how moral and selfish economic considerations may combine in a given case to support a protectionist measure. The basic question is only value, which determine these chapters, which considerations determine these chapters, because we have a very interesting, we can have a very interesting perception here that only values that have a strong trade relevance make their way to the negotiation table. So not all values get into free trade, the new generation free trade agreements. Well, there are exceptions, of course, but basically the FTAs focus on values which are of trade relevance, like labor standards and environmental protection, because these generate costs and, of course, confer or may confer competitive advantage on the producers of one of the countries. But at the same time, we also have to highlight that only those regulatory issues are singled out that are backed by a strong value-driven narrative. So there are a lot of regulatory differences between the states which generate a competitive advantage or disadvantage, and they do not become part of these treaties, like electricity prices or tax allowances. So actually, we have both Baptists and bootleggers in this story, and both of them are important players. And well, let me start with two relatively provocative quotes from various EU documents or EU sources to lay the groundwork for this question and my answer. The first question is probably a little bit cynical. Isn't it all about the money? Well, according to the EU, sustainable development, labor standards, environmental protection, well, these are not about the money. In the context of the TTIP, which is well, of course, a long story, in 2015, the European Commission stated that trade is not just about our economic interests, but it's also about value. So it's really more than some selfish endeavor to maximize our profit. But let me bring to you another European story which shows how these values and seemingly non-selfish economic considerations shape the development or have shaped the development of EU law. In the founding treaties of the European Union, there's still a provision which guarantees equal pay for equal work, more specifically equal pay for men and women. And if you read the original version of the founding treaty, you may find it a little bit strange, because the founding treaty is really an economic constitution. It created an economic constitution for Europe. So it was about free movement of goods, free movement of services, competition of the market. So that was really a very enhanced free trade agreement. Let me say it that way. Of course, it was a customs union, but it was basically about the internal market and economic intercourse. But there was a provision, as I mentioned, which guaranteed equal pay for men and women. Now, what was the consideration behind that? I'm quoting again the European Commission. So that's there was anecdotal evidence for this, but a few years ago, the European Commission actually confirmed the main motivation between having the requirement of equal pay in the primary sources of EU law. Some EU countries, for example, France, and most specifically France, had adopted national provisions on equal pay for men and women much earlier than the others, and these countries were afraid that the cheap female workforce in other countries, for example, from Germany, could put national businesses and the economy at a competitive disadvantage owing to lower labor costs. Now, this was the 1950s, very, very long time ago, and the basic idea was that lower pay to women in Germany is a competitive advantage against French producers. What can you do? We should introduce a labor chapter. Of course, this was a very, very modest labor chapter. It was not a chapter, it was a single provision which guaranteed equal pay for men and women. But the Baptist bootlegger coalition behind this provision is pretty clear. And here, very probably, the bootleggers, the selfish economic interests, were the dominant force, the dominant reason why this provision was included. So what makes value standards relevant for free trade agreements? Of course, it's a good argument, and it's a very legitimate argument to say that competitive advantage in international trade is recognized. That's fine, but only fair competitive advantage should be recognized. And again, you can turn the whole debate into a debate about morals and moral values and so on. But as I noted, and that's actually the conclusion, one of the conclusions of my paper, that only some values make their ways to the free trade agreements, and we can identify two preconditions in this regard. So there are two preconditions which make value standards relevant for free trade agreements. There should be an exceptionally high regulatory competitive pressure. So competitive pressure, competitive advantage should be high. Otherwise, I mean, if there's no trade relevance, these value standards will never make it to the free trade agreement or agreements. And second, there have to be ossified local value standards. So we need a local electorate who is afraid, who has some sort of a project fear, and is afraid of foreign lower standards. If we have these two preconditions, then the value standard has a good chance to become part of a free trade agreement. Otherwise, this doesn't work. So let's say electricity prices or public utility prices, yeah, they may generate a huge competitive advantage, but they are not ossified local value standards, so they will not make it to the to an FTA. And we can, of course, bring up a lot of examples of human rights, fundamental rights, freedoms, which are important local values in quite a few countries, but they do not really generate a competitive advantage. So they may have a trade relevance, but that may not be high enough. But my final conclusion, and this is why I'm saying when trying to answer the question whether it is the chicken or the egg, and I'm saying that it's actually both. So my conclusion is that this is a steam valve function. I mean, what's assumed by labor and environmental chapters of FTAs, because on the one hand, so it's a much ado about nothing sort of story. What we are seeing here, at least this is my reading of labor and environmental chapters in the free trade agreements. First, we are dealing with core values, so we are not dealing with labor protection, but we are dealing with the international baseline of labor protection and international baseline of environmental protection. This means that these core standards, which are included in the FTAs, normally do not really impact on competitive advantages and do not really make a difference. The impact on individual industries may be huge, so I'm not denying that, but the overall impact, that's not significant based on the statistic available and the empirical research. So this, for instance, the USMCA is a good example where the automobile industry was singled out. Well, that was a single industry which was addressed by a certain set of provisions. But again, the requirement which was introduced, minimum hourly fee, that had nothing to do with core values or core labor standards, that went way beyond that. Most FTAs provide for a minimum wage, but the minimum wage is determined on the basis of the local conditions and circumstances, and because of this reason, the compliance with these core values or core labor standards do not really generate too high costs for developing countries. They do make a difference, but they do not make a huge difference when it gets to the competitive advantage in terms of labor costs. So that's probably the most important issue here. And actually, the USMCA provisions on the automobile industry and the hourly fee show that if the agreement is limited to core standards, then actually that wouldn't make a difference in terms of competitive advantage. So at the end of the day, the whole story appears to be a nice redirection activity. Here, states are actually displacing a real but invariable circumstance, which is the cost advantage, with a changeable but relatively insignificant one, the core standards, in order to dampen the political resistance against free trade. And the second important point is that very probably the strengths of the motivation behind these agreements is really not as strong as the motivation to get the trade benefits at the end of the day, which is pretty much shown by the effectiveness of the dispute settlement mechanisms and the differences between the various between the labor and environmental chapters of the various different FTAs. But at the end of the day, I think the message of these chapters is positive, because this is probably the most constructive defense mechanism against the project fear generated by free trade agreement, because at the end of the day, what happens is that universal values are promoted in international trade, even though in a relatively ineffective way. So there's I think there should be nothing against these chapters. Actually, they are a welcome contribution to the development of international trade. Thank you very much for your attention.
Thank you so much, Csongor. What a very, again, once more, what a nice, clear presentation to the very point of what we are discussing. And since Csongor was the one proposing the title of our panel, it's not at all surprised that he answered exactly the question about the normative values and about the money. Or I will rephrase maybe Csongor question to all the panel about asking ourselves if trade is still the core of new generation agreements, and what the implications are of these non-trade issues that, as we call in the trade language, or that are directly related to regulatory dimensions that actually end up impacting in the reshaping and reorder of our economies. Highly impact in terms of normative values. We have a question or a comment on the chat from Patricio, and Patricio is noting, says, "Good afternoon to all. Thank you for the very inspiring speeches. May I ask why nothing has been said so far about the EU? That must be the Eurasian Economic Union, if I don't misunderstand, the Eurasian one, a tool to spread normative values among the member states. The EU," oh, I cannot pronounce that, I'm sorry. My English has become horrible, Patricio, I'm sorry. "The Eurasian Economic Union has concluded a number of FTAs with third parties, and tomorrow the Eurasian Union Serbia FTA is entering into force, opening a number of issues on the normative level between the Serbian participation to said FTA and the Serbian accession process to the EU on the other hand." Thank you to share the comment. I'm not a specialist on Eurasian Union. I don't know if some of you want to make a specific comment about that agreement has been working over normative values, but if not, well, thank you very much for your comment, Patricio. And for the next time in the panel, we will try to include somebody from Mercosur, from Eurasian, and we will do a whole comparative global regionalism for the discussion. Then I have another comment by Kathleen Clausen. She says, thank you to everyone to the great presentations with so much great information. Perhaps 2 questions to start. To David, what's your sense about the way forward on environment among the USMCA parties? I haven't read Environmental Council statement yet, so maybe there were keys there. It says, given that given that the Democrats could get the climate change language into the agreement, but the Biden administration see that as a priority, and on that find support at least from Canada, where do we go from here? Perhaps besides adding Paris to the multilateral list, Paris, the Paris Agreement. And then we have also makes a comment. He says, many thanks to all panelists. Jessica Lawrence, it is possible to integrate commitments to effectively implement national agreements such as the Paris Agreement into the World Trade System. How? So we have 2 questions that actually ends up with the Paris Agreement, one's for Jessica, one's from David. I will like to add another one gets coming into questions. I will read all of them and then we go through each one of you to end the panel on time. Ioana Siobanasu, she asked, Jessica, would you favor an EU-UK like final agreement in future negotiations between EU and weaker partners, or would you stand by the principles of such partners feeling free to negotiate a trade sustainable development chapter in the same fashion as China? I guess 2 competitive interests at stake. Thank you so much for all the comments we are receiving through the chat. Kathleen Clausen said, I will withhold my second question given the time. Thanks, Kathleen, because we are running up now. And I would like to ask to the whole table one little more that has with the relationship between these new kinds of or generations of trade agreement that you have studied so in detail and the multilateral system. And my question is something like this, like you see that many people, according to many people, we were heading to a globalization organized through global value chains. Global value chains actually showed to be, had a certain regional bias. The COVID has emphasized that bias because global value chains were very difficult to sustain in the pandemic. People restricted sports or prioritized domestic, domestic and strategic partners. Talking about now about regional globalization. So my question would be that if you think that the trade agreements that you have studied of the new generation that have things that we have not, regulatory part that we have not at the WTO, will be the expression or the reflection of this kind of regional globalization. That would be short one. So let's start then in the same order we did this panel. Professor Pasha, we have 12 minutes to end up this panel, so that gives us very short answers, 2-3 minutes, and we have to move. I'm sorry about that.
Sure. Let me respond to these issues very briefly. First to Patricia about whether or not we can incorporate the Paris Agreement or other environmental treaties into the WTO agreement. That would be difficult. The reason is that it's always difficult to amend the WTO agreements. So I think the at the WTO, they have been talking about a lot of interaction with the environmental treaties, but I don't think they have talked about amending WTO agreement or incorporate environmental treaties. And also briefly to response to Iona's questions, and this question was actually posed to Jessica. So this is actually very interesting when Jessica talked about the diversion in 2020. I never thought about that way. So on the one hand, you have EU-China. On the other hand, you have EU-UK. So I think EU-ASEAN or agreement or EU-Singapore, EU-Vietnam FTA are sort of in the middle, right? So meaning that now we got 3 EU models. So So I think the EU-China agreement will not be seen as a model because China is quite unique in terms of power. So, and my sense is that the EU, Singapore or EU, Vietnam FTA will be a more suitable model for other developing countries. So that's my sense. Thank you.
Thanks, Pasha. Professor David Gantz?
Thank you. I think I'll confine my remarks, hopefully very brief, to Kathleen's question, because I think it's a good one. As Pasha pointed out, it's very difficult to amend these agreements. I think the Biden administration is probably seriously interested in using the mechanisms at hand, which is our pretty good environmental chapter in the USMCA and what looks to be an effective state-to-state dispute settlement. But I think they'll have to pick their actions very carefully. And I think adding the Paris Agreement to the list would be a nice idea, but it will be strongly opposed by the Republicans. Talking about climate change, adding language there, same issue. If I were the Biden administration, I would not want to spend a lot of my political capital on those issues. Rather, I try to be very selective and find a few cases. I think one of the potential issues for environment and climate change is probably going to be challenging Mexico on its going backwards. It's essentially trying to get rid of wind and solar energy investments and be preferably use Pemex and CFE, which basically is a way of burning oil or maybe even coal rather than alternative energy. That's where I would go, and I suspect that issue may well be fought in the context of violating the investment provisions of the agreement. Beyond that, it just seems to be, particularly in the next couple of years, the Biden administration's plate is very full on issues which I'm sure it believes have a higher priority than changing the language in USMCA. Thank you.
Thank you, Professor Gantz. Jessica?
Hi. Okay, I will just only address a couple of the things. First, on the Eurasian Economic Union, all I will say there is that, countries, aligning with one party or another in order to express political values, and there being competition on a political level over trade agreements is nothing new. And I will leave it to our Hungarian colleague to work out that relationship a little further from the regional perspective. On to the next question about how it is possible to incorporate commitments to effectively implement international agreements. The way that they're doing it in these EU agreements so far hasn't been super effective because they don't have a lot of enforcement mechanisms attached to these chapters. Of course, you can sort of get panel reports and this kind of thing, but then it kind of relies on sort of intergovernmental sort of pressure and stuff like this, right? I mean, but there's no reason that if the parties wanted to, whether that's in bilaterals or regionals or at the WTO, that they couldn't write sort of rules that integrate whatever other multilateral agreements they wanted to. I mean, if that was something that they could get everyone to agree on. So I'd say that's just somewhere, if that's something you want to work on. That's something you could start putting pressure on, because there are sort of strong linkages between sort of trade and environment when it comes to sort of unfair competition in this respect. Joanna, thank you for the question. I would say that I am in favor in general of, my personal political opinion, though, is that, I'm in favor in general of not siloing trade and investment out from other social issues when it comes to negotiating and concluding these agreements. And so I like the movement sort of thinking about these things as being mutually intertwined, and therefore, like, it doesn't have to be one size fits all, but I certainly am, let's say, supportive of the idea that these things should be thought about together at the very least. And I will stop there.
So much, Jessica. Professor Csongor.
Thank you very much. I would just have two remarks which generally address some of the points raised, though I think I briefly touched upon these in my presentation, so I will try to keep it very short. I think, well, we can have these chapters in the systems, I mean, in the FTA, so in the international trade system, but basically what causes the advantages, the competitive advantages, are not the core standards, but competitive advantages go beyond that. So let's assume China agrees to recognize trade unions to introduce a minimum wage, of course, based on local living costs. They will still have a huge competitive advantage when it gets to labor costs. So even if there were compliance, of course, you can demand compliance with higher standards, but there's no legitimacy for such a requirement. So when you just comply or require others to comply with core standards, that doesn't really make a huge difference. And the second point is, and again, I'm really getting cynical about this issue. I very much love to see how, to see in the various presentations how different FTAs diverge, like the EU Singapore FTA and the CETA with the Canadian one, or the UK and the China. So it's I'm really not sure if we are generating values here, or we're just recognizing the values the partners, the contracting partners already comply with, and we just put a hat on it and say that, okay, now this is part of the treaty. But I'm really not sure if these chapters really generated more values or a higher compliance level with core values in the international trade. Sorry for being so pessimistic.
No, it's okay. Thank you so much, Csongor. We are almost on time. We have 1 minute left. So I will just say thank you to all of you. It has been a great panel, and I hope that this dialogue will continue in other seminars, conferences, virtual like this one, or presential. Who knows that we will meet each other with our colleagues today that participated today in this panel. So thank you so much, and I hope to see you soon.
Thank you very much.
Thanks a lot. Thanks.
Thank you, Csongor. Yeah.
Thanks.